Good morning, this is your Kelso Report for Monday, January 30th, and I'm your host, Clark Kelso. We begin with the California Supreme Court, which on Friday resolved one of the most politically charged questions this year by holding in Vandermost v. Bowen that the Certified State Senate District Map produced by the Citizen Redistricting Commission should be used in the 2012 elections, even if the opponents to that map were able to secure enough signatures to put the map on the ballot for a referendum. According to the court's precedents, when faced with this type of choice about what map to use for interim elections, the court must consider what maps are reasonably and practically available, and then evaluate the pros and cons of each potentially viable map in light of the constitutional scheme and criteria set out in Article 21 of the California Constitution. The court undertook that task and unanimously concluded that the Commission's map was clearly the most appropriate one to use. The court's holding is consistent not only with the way prior California Supreme Courts have dealt with the problem, but also with the spirit of the United States Supreme Court's recent opinion, emphasizing that federal courts should defer for interim map purposes to maps enacted by a legislature, even while the federal court is considering constitutional challenges to those maps. Republican groups predictably blasted the California Supreme Court's decision, but their anger comes from the fact that Democrats may achieve a two-thirds majority in the Senate under the Commission's maps, a political consideration that the California Supreme Court properly ignored in its deliberations. Now we turn to some Ninth Circuit opinions, first in the area of bankruptcy law. There is an old saying that he who lives by the sword dies by the sword. Well, something akin to that applies to the bankruptcy debtor in Morello Maddox Properties v. Bank of America. Morello had a real estate empire which it operated by separately incorporating some 50 or more subsidiaries, each one apparently containing a single real estate property. The company managed them as a consolidated entity, but maintained the separate corporate structures. The bankruptcy plan of one of those subsidiaries was before the Ninth Circuit, and the issue was whether the debtor was subject to the Bankruptcy Code's single asset real estate provisions that have the effect of waiving the automatic stay in favor of that property's secured creditor. Applying the plain language of the statute, which said nothing about a single asset subsidiary that is actually part of a family of other subsidiaries, the Ninth Circuit held the single asset real estate provisions applied. If Congress wants to enact a whole business enterprise exception to the single asset real estate provision, it is of course free to do so. But until then, the Ninth Circuit is going to apply the statute as written. Next, a case involving municipal liability. Now, in order to state a claim for municipal liability under Section 1983, the plaintiff must do more than make conclusory allegations of the elements of the cause of action. Instead, there must be sufficient allegations of underlying facts to give fair notice and to enable the opposing party to defend itself effectively. In the case of A.E. v. County of Tulare, the plaintiff failed to include those specific factual allegations in a complaint that alleged generally the county had policies and procedures that were the moving force behind the injury suffered by the plaintiff. In this case, a minor placed in a foster home was sexually assaulted by an older foster brother. Under Section 1983, a municipality is not vicariously liable for its own employees' torts, and can be held liable only based upon its own policies, customs, or practices. Well, the problem with plaintiff's complaint was that it did not point to any specific policy or procedure as the moving force. And absent that specificity, the plaintiff's complaint was deficient. But the Ninth Circuit held that the district court went a little too far and should have given the plaintiff one opportunity to amend to add those particulars. So it reversed the dismissal with prejudice and remanded so the plaintiff could try to cure its pleading defects. Finally, in the area of immigration law in the Ninth Circuit, in Tyson v. Holder, the court reviewed the Board of Immigration Appeals' rejection of an alien's request for discretionary relief under former Section 212C from removal as an alien convicted of a controlled substance offense. The alien was convicted prior to the amendment of 212C pursuant to a stipulated facts agreement based on a reasonable expectation that whatever happened there would not negatively affect her immigration status. When Section 212C was amended in 1996, it changed the rules so that such a conviction had preclusive effect in the immigration context. The Ninth Circuit reversed the BIA, concluding that the stipulated facts trial in this case was substantially equivalent to a guilty plea for immigration purposes, and holding that applying the repeal of Section 212C relief would produce an impermissible retroactive effect upon the alien. So the court remanded for consideration of discretionary relief under Section 212C on its merits. Next we turn to some California Court of Appeal decisions that were issued on Friday. First, in the area of contract law. The 4th District issued what amounts to a law school examination answer. That's what it described its opinion as. In C9 Ventures versus SVC West. The case involved the question of whether an indemnification on the back of an invoice that was never signed by the buyer became part of the contract. The trial court had analyzed the case under Division 2 of the California Uniform Commercial Code dealing with sale of goods. And as I'm sure you all recall, the sale of goods provisions include everyone's favorite UCC Section 2207, dealing with the topic of terms that vary from the original terms of the agreement. The 4th District here gets an A+ for first noticing that the contract was actually not a sale of goods contract. Instead, the transaction was for the lease of personal property. In this case, the lease of 8 helium-filled tanks used to inflate balloons. One of those tanks fell over and injured a young child. Well, personal property leases are not covered by Division 2, sale of goods. They are covered by Division 10 of the Uniform Commercial Code. And Division 10 does not have anything at all like Section 2207. So under traditional contract rules, the indemnification clause never became part of the contract because the lessee never gave his assent to it. Never even saw the clause, for that matter. The court also held that even if 2207 or something like it did apply, it would not change the result because the indemnification clause was a material change in the contract and therefore would not become part of the contract absent the lessee's express agreement, which did not exist. Next, we have a state habeas case. Now, back in 2005, the defendant pled guilty here to possession of diazepam, that's as a felony, as well as driving under the influence and a few other offenses. Diazepam is essentially Vicodin. He received 3 years of formal probation. In 2010, he filed a habeas petition challenging the felony conviction for possession on the ground that possession of diazepam was at most a misdemeanor under the law, not a felony. Now, although the petitioner was correct that the possession charge should have been at most a misdemeanor, the 5th District held in People v. Miller that this could not be the basis for a habeas petition, and rejected his habeas petition on grounds of equitable estoppel, since the petitioner had voluntarily consented to the guilty plea and had discovered the error only 5 years after the plea had been entered and after he was already released. We have another criminal sentencing case, this one involving probation conditions. The defendant in People v. Hughes was found guilty of various drug offenses related to cultivation, possession, and transportation of marijuana. One of the conditions of his probation was that he refrain from using medicinal marijuana, a condition he challenged on appeal. The 4th District affirmed the condition, noting that he was convicted of marijuana-related offenses, and there was evidence that a physician had prescribed marijuana use for the defendant only after the most cursory of examinations. It thus appeared to the court that the defendant was using the state's medical marijuana law as a cover for engaging in otherwise unlawful cultivation, possession, and transportation. Our next case comes up in the area of civil procedure and judicial disqualification, but it's really a preemption case. Subdivision A2 of Section 170.6 of the Code of Civil Procedure provides that when a court of appeal remands a case to the Superior Court, and the trial judge in the prior proceeding is assigned to conduct a new trial in the matter, the party who filed the appeal may file a motion to disqualify the judge within 60 days of the date the party or party's attorney has been notified of the assignment. Well, Los Angeles Superior Court has a local rule that provides the time period for filing such a motion shall begin to run from the date of issuance of the remititure by the Court of Appeal. Now that rule clearly shortens the time available for filing a motion to disqualify, and so the 2nd District easily held in Ghaffar Pooler versus Commerce Plaza Hotel that the local rule was invalid in light of the state statute. It's one of those pesky local rules that can trip people up, and quite often it turns out those rules are preempted by either a statute or by the state rules of court. And that's it for today's Kelso Report. Have a great day in the law.